My name is Mary Cheney. I am the owner and managing attorney of the law offices of Mary and Cheney, PLLC, better known as the Cybersecurity Law Firm of Texas, and welcome to the Breach Whisperer blog. In this blog, we will be talking about privacy and cybersecurity issues worldwide. For those of you that are familiar with my written blog, this is an extension of that or replacement for it, depending on my time and my ability to record or write blog posts. So, I mean, if you guys are interested in my previous works, if you can click on the link below, and it'll take you to my law firm website where the blog posts are there. Don't forget, speaking of links, don't forget to like and subscribe to our channel. So I know you guys are asking me why in the world or would we want to watch anything about cybersecurity and privacy. I mean, it can be highly technical, it can be full of acronyms, it could be legalese, it can be technical terms. And, because I feel like cybersecurity and privacy are not going away. And, I want to be able to share the knowledge that I have. I mean, in this video blog, we will be trying to educate the masses on cybersecurity and privacy. So, and things that you come across on a daily basis that you may not even think about that may affect you going forward. So, we will do this through articles, excerpts of speaking events that I may do, just basically any random things that I come across and find that I'm hitting record on certain things. I think that it's very important. I have a unique perspective. I think, based on my background, I could look at things from the cybersecurity perspective, the privacy perspective, it could be the hacker or the criminal perspective, the law enforcement or investigator perspective. It's so many different things that, are happening in cybersecurity and privacy that you guys may not think about. And being an owner of my own law practice, the things that come across my desk are amazing. So be warned, I may switch hats mid-sentence. And hopefully it's just to get you guys to think about things and in a different way. And please feel free to send me anything that you may find that you think I may find interesting. It may just make the blog, you never know. Caveat here, I'm a public speaker. I don't believe in too many edits. If I mess up, I mess up. So let's get started on your privacy and cybersecurity journey. Is it time for your annual wellness check? Cybersecurity and privacy programs, once implemented, can't get stale. It's very important that you take a look at those at least on a regular basis or semi-regular basis to ensure that you are complying with industry best practices, that there haven't been any laws implemented in your state that actually affects what you're doing from a day-to-day perspective. Whether it's, trying to figure out, do I need cyber liability insurance, and what kind of insurance should I purchase? So it's very important to take a look at those programs. If you need a wellness check, please reach out to the Cybersecurity Law Firm of Texas for help. Hi guys, welcome to the blog today. So I have a couple articles that I was looking at about breaches in healthcare. Healthcare is one of those things that breaches, they've been under attack for a while now, and breaches continue to happen. These two articles that I was looking at, it was perplexing to me because one was about an unencrypted laptop, and one was a breach that occurred because of email and sending healthcare information by email. And it just got me to thinking, like, what, are we still doing that? I mean, um, unencrypted laptops, that really shouldn't be a problem anymore. And sending stuff, from a data leak prevention perspective, sending stuff through email with sensitive data in it should best practice. I was doing that 10 years ago. So, I mean, it becomes a, what is it about healthcare organizations that they're failing to do some of the things that let's say, for instance, banking, which is unfair to compare, but banking, it was under attack for years before they shored up their doors. And then it flows down, right? Your criminals flow down and they go for the weakest link. But healthcare has been in the news for a long time now, and I think HIPAA itself, the Health Insurance Portability and Accountability Act, 2002, I want to say that came out. So we've have some years in the game here, and to try to understand what actually should be going on from a healthcare perspective and protection of healthcare data, and what is going on. I mean, if you read the headlines if you just go to the HHS blog and read their press releases, it's just it's perplexing to me. I understand that now we've gone from, it all depends on the area of the country. I've lived in Ohio. I was born in Ohio. I've lived in Los Angeles. I've lived in Maryland. I've lived in Texas, in Houston, and Dallas. I've lived in Pennsylvania, and different areas of the country have different types of healthcare. Down here, there's a lot of urgent care type of facilities, a lot of small niche dentist offices, people that are not in a hospital organization, but have healthcare information, have the same data, and I'm sure that exists everywhere. Like I said, when years ago it was more hospital organizations than it was the small niche businesses that exist now, and urgent care and things like that. But the Department of Health and Human Services Office of Civil Rights, which enforces HIPAA, they don't care. I mean, small, medium, or large organizations that actually have a responsibility to comply with HIPAA. They don't care how large or small you are. They say HIPAA is HIPAA, and you should be complying with it. And one of the articles was talking about an ambulance company and the ambulance company, I think it was the one that lost the laptop, and they went in there, and I'm gonna tell you three things that if you are a healthcare organization that you have to have, and you need to have, and you better have if you have a breach, because these are some things that the Office of Civil Rights is going to come in and going to look at you, whether you perform a risk assessment and whether it's written down, whether you have a security awareness program, and whether you have policies and procedures. They're going to if you don't have anything like that, then you're going to automatically get fined and you're going to settle, because those are the basic types of things. And these aren't things that should be new to the understanding of how you develop a cybersecurity and or privacy program. You have to conduct a risk assessment. If you have not conducted a risk assessment, you don't know what to do, and you don't know where to go, and you don't have a strategy. You can't perform a strategy if you don't know where your problems are. So those are three things that you guys should have. And sending things by email. I mean, I've worked with small and mid-sized companies before. I know the understanding, or they're a lot of them are hedging their bets. They don't want to do anything. They don't want to, they want to keep their head under the radar. So they feel like, oh, if no one's after my data, no one's after me, so I shouldn't have to do anything about it, not really understanding that it's not personal. It never is personal. If you are vulnerable to a particular type of attack, you will get hit. Look at the ransomware stuff that's going on, that continues to go on out there. It's not, well, ransomware is becoming more targeted, but initially it wasn't something that was targeted. It was just something that was taking advantage of a vulnerability in the system. So just understand those three things that you need to have, and especially if you're a healthcare organization, and understand what you need to do to prove that you are being reasonable in your steps that you're taking to comply with HIPAA. So thanks a lot. Talk to you guys soon. Have a good one. Hey guys, I wanted to amend my statement before my random thought. HIPAA came out in 1996. The privacy rule came out in 2003, and the security rule came out in 2005. As I shared with you guys before, I go with my bloopers, and I'm just amend what I said earlier to the correct date, correct year of 1996 when HIPAA came out. But my random thought for today is what something that jumped out of me when I was reading about an organization. The organization we were talking about that had the email issue, Sinai Health Systems. And this is what they said in regards to their breach. They said Sinai said experts found no evidence that any of the emails containing patient information were opened or that any of the personal information has been misused. Now, unfortunately, you always have to be wary when you make statements like that. Companies will always make those particular statements, but having no evidence and meaning you can prove that it didn't happen is completely different, two different things, because no evidence could be I just didn't have the log information to say one way or another. That means that Sinai doesn't have any evidence, but that doesn't mean that they can actually prove that it wasn't being used, or it has not or will not be used in the future. So companies always need to be mindful when they're making these individual statements, and they have their attorneys, they have their PR folks, and they're going to say whatever they're going to say. And it's you always, when you're reading these things, understand and ask yourself, can they prove it, right? And so me working ops as long as I did, and running incident response as long as I did, there was a lot of things that we had no evidence that happened, but that's because we didn't have that information in our systems to be able to say one way or another whether we may not have access logs turned on, right? So especially an email, if it's been read, or, how do we know once you send an email whether or not it's been read by the person or the receiver? You're just making the assumption that the receiver was the appropriate person. I mean, in this case, their emails, they didn't really get into where those emails went. Were they internal? Did they get sent to someone externally? And once you send an email out, unless you have a read receipt, and even if you have a read receipt, you don't know if the person that received it is the person that is meant to have it, that's not the hacker, or whatever. So just be mindful when you're reading these things about these breaches, that companies, there are things that they play with as far as words go. And honestly, whether or not they can say that the information was opened or if it's been misused, it doesn't matter from a HIPAA perspective. From a HIPAA perspective, it's the loss of the data that actually triggers the breach. So just information out there. Hopefully you guys have a great day. Thanks. Bye-bye. Thanks again for listening to the Breach Whisperer blog, sponsored by the cybersecurity law firm of Texas. Don't forget to like this post and subscribe to our channel so you can get updates of when we post new things on our channel. In addition, spread the word for me, right? Let's get out there and tell a friend, and so they can all become paranoid cybersecurity and privacy people. Don't forget, if you would like to connect with me on socials, you can connect with me on Twitter at Mary N. Chaney. Use my middle initial always. For my nonprofit, Minorities in Cybersecurity, that is at Mike Leadership, and Instagram and Facebook at MN Chaney Law. And you can find me on LinkedIn just by searching for my name. So if you're interested, connect with me. Thanks again. And just remember, awareness equals knowledge.